Medical diagnosis. Hey, we've all been diagnosed by a doctor. Might be a common cold, might be a broken arm, could be any number of things. We've all had diagnoses. But what happens if that diagnosis you get is wrong? What, if anything, does the doctor or clinic that provided that diagnosis owe to you? Well, that brings us to this week's case. It involves a man in Washington, D.C. Fellow went in, had an examination, was told by the clinic he was going to that he was infected with HIV, in short, that he had AIDS. Well, he got pretty distressed by all of this. He did go on, later got a second opinion on this, and lo and behold, in the second opinion, the clinic there told him, you know what, those first guys, wrong, they messed it up. You do not have AIDS, you don't have HIV, you're not infected. Don't worry about it, buddy. He said, whoa, this is really terrific. But, hey, you know, I went through a lot of hassle as a result of this. I'm laying awake trying to figure out how many hours do I have left on this planet. I'm trying to figure out what I'm going to do with my property. I'm trying to figure out who I should leave it to. I'm trying to figure out, man, I was just really upset. Went back to the first clinic and said, I think you guys owe me for all of this grief that you caused me by this misdiagnosis. They said, no, we don't. We don't owe you. And their lawyers then responded, saying, we don't owe you because you were not in the zone of physical danger. Zone of physical danger? What the heck does that mean? Well, there's a concept in the law that you've many times heard when you've heard the explanation of assault and battery. Now, most of us think that assault and battery means somebody hits you, but that's really not what it means. There are two separate things that happen. Assault is when you think somebody's going to hit you, and you're in the fear of immediate physical injury. The battery is when somebody, boom, actually hits you. Now, you don't have assault usually unless there's the possibility of battery. They don't always go together. We always hear it as assault and battery, but they're really two separate things. But you can have an assault if it looks like somebody is sitting there with a baseball bat and about to hit you across the shoulder or something, and you're saying, whoa, well, that flinch, that movement, that kind of fear is the kind of injury you suffer from an assault. Battery is when you bang and actually hit on the shoulder, and that bruise, that broken bone, whatever it may be, is the actual physical injury. So the law finds that in order for you to have an emotional distress claim, there must be a reasonable belief that you're going to suffer the actual physical injury. And in this instance, the medical clinic said, hey, there was never going to be any physical injury. He didn't have HIV, you were never going to have HIV as far as we knew, and therefore there was never the chance that you're going to have physical injury. Well, the case went to court and then went up on appeal. And on appeal, the court really gave this a lot of consideration. And they said, you know what? When you go in for medical diagnosis, there's a special relationship. This special relationship is between a patient and a doctor. The patient reposes trust in the doctor to provide a diagnosis which is accurate, upon which the patient will act. Irrespective as to what the diagnosis is, the patient will do something. If the diagnosis is no injury, the patient will do nothing. If the diagnosis is injury, the patient will take that course of treatment to deal with the injury. So therefore, it is known by the person providing the diagnosis that the words they speak will have consequence on the person to whom they speak. Given those circumstances, the court said there is a special duty to the patient, and there is the realization that whatever the doc says will be acted upon by the patient and could inflict emotional distress, even if it's correct. I mean, if the guy really had AIDS, he'd still be distressed, but that's a natural consequence of an accurate diagnosis. But here, it was an inaccurate diagnosis. It was wrong, and he was subjected to all kinds of distress as a result of that, and the court said, you know what? You doctor, you clinic, do owe him for that distress. So the case was then remanded, meaning sent back to the trial court, and it would have to go to trial. Now, what's the point of this case? The point of this case is very simple, and that is if you get a misdiagnosis, now it varies from state to state, so don't get too excited about this if you live in a state where this doctrine isn't recognized currently. But you know what? You might be the case where it's recognized. The law is constantly changing. But in a nutshell, If you suffer distress as a result of a diagnosis, a medical diagnosis that is wrong, you may actually have a cause of action against the doctor, the clinic, that made that wrong medical diagnosis. Okay, hey, we bring you these cases every week so you understand how the law works. I'm David Allen.